this segment we're going to get into might actually be competing with our Fannie Willis segments for my favorite segments on the show. We got to talk about Tony Buzbee, y'all. So Tony Buzbee is back under the gun, and it's looking like, in my opinion, that Tony Buzbee is getting blackballed by the Southern District of New York. It is bad, man. And shout out to Megan Cuniff. We're going to look at a couple of documents that were posted by her over on X. Make sure y'all go follow her on X because she does a great job reporting on this and getting us access to these documents. So what does she say happened recently over this past weekend? A judge won't let a woman remain anonymous in another Tony Buzbee lawsuit against Diddy, taking L after L after L. The order notes Buzbee's declaration is subsequently identical to declarations filled out the same in other Doe versus Combs cases in this district involving different plaintiffs and facts. So basically he's copy and pasting. Let's see what the judge says. The Buzbee declaration supporting the plaintiff's motion states that the plaintiff has not spoken publicly about the incidents that underline the causes of action in her complaint in paragraph 7. But as defendants acknowledge, the declaration is neither sworn nor made under the penalty of perjury. The Buzbee declaration is not sworn or made under the penalty of perjury under the laws of the United States and is thus inadmissible. Come on, Tony. We hold that 28 USC 1746 requires that a certification of the truth of a matter be expressly made under penalty of perjury. The court also notes that the declaration is substantively identical to declarations filed on the same day. Oh, man. In other Doe versus Combs cases in this district involving different plaintiffs and facts, which raises serious questions about the declaration's reliability. Tony Buzbee's copy and pasting these things and just sending them out. Say, hey, did you know Diddy? You want to come get a lawsuit? Come and get one of these. What's your name again? Don't worry about it. Male, female. Okay, John Doe, got you. This one. We'll figure out the details later. You're female? Oh, you were at a barbecue with Diddy? Got you. Jane Doe. Boop. This is embarrassing, man, for someone who's supposed to be a true professional and one of the best. Either way, the judge is concerned here. What else does the judge say? In any case, the seventh factor still weighs in the plaintiff's favor, absent any evidence that plaintiff's identity has not been kept confidential. And this isn't the end, guys. This isn't the end. Megan also says another judge has rejected the anonymity for a Tony Buzbee client in a lawsuit against Sean Diddy Combs. This is another L. What does the judge say? Oh my gosh. We've got John Cronin. There we go. John Cronin, the Honorable Judge John Cronin, says, this case is one of dozens filed in this district by plaintiffs who allege assault at the hands of Sean Combs, globally known by the stage name P. Diddy. Like many of the other plaintiffs, the plaintiff here commenced his action anonymously. Using the pseudonym John Doe, plaintiff filed his complaint on November 20th of 2024 and simultaneously moved for leave to proceed anonymously. On November 22nd, 2024, before any defendant had yet appeared, the court issued an order allowing the plaintiff to proceed as John Doe initially, on the condition that leave to appear anonymously shall, quote, end quote, remain efficient only until the latter of 30 days following the service of the complaint, or the court's ruling on a timely renewed motion to proceed anonymously. So gotta put in another motion there. The court added that if the plaintiff failed to file a renewed motion within 30 days of service of the complaint, it would order disclosure of his name. So no more hiding. Defendants, which include Combs and several of his businesses, now have been served with the complaint and have appeared. On January 13th of 2025, the plaintiff timely filed a renewed motion to appear anonymously. On March 4th, 2025, defendant opposed the motion for the following reasons. All right. Then what do we have here? The order says, accordingly, plaintiff's renewed motion to appear anonymously is denied. The plaintiff shall file an amended complaint with his true name by April 4th, 2024. So this man about to be exposed this week. If an amended complaint is not filed by that date, or if the deadline is not extended, the court will dismiss the complaint without prejudice. Oh my goodness. Tony Buzbee, what are you doing, man? The clerk of court is respectfully directed to close docket number 14. So they say if they don't show up or ask for an extension by April 4th, they're out of there. How embarrassing, man. And again, it says the vague representation, this is what the judge says, as to individuals other than the plaintiff is insufficient to establish a risk of physical harm to the plaintiff himself. Mainly, you don't have enough to make this go through. And then we've got another one in here. And this is where it starts to get interesting. So we talked about Tony Buzbee last week, and he had an interaction with local counsel, we'll call her, and that is the attorney ClassE. And what Judge Mary V was alleging is that the attorney ClassE, she allowed Tony Buzbee to use her credentials to file a lot of these claims that are just getting demolished left and right. Now, the attorney ClassE, she sent a letter back to the judge and say, hey, judge, that's not true. Yeah, maybe I didn't do my due diligence and find out if Tony Buzbee was admitted into the Southern District of New York, but I reviewed these claims myself. I saw that they were sound claims, and I went ahead and I'm the one that filed them. I didn't give Tony Buzbee access to my ECF, right? So now Judge Mary V actually responded and said, she says she don't care. And that the attorney ClassE is actually looking at possible sanctions. We're going to get into it right here. Shout out to Megan Cuniff again. She says Judge V has set a sanctions hearing for the New York lawyer who filed Tony Buzbee's Southern District of New York lawsuits against Diddy and the one against Jayz. Ms. ClassE shall show cause why she should not be sanctioned for making false or misleading representation to this court. Dang. What do they say? Judge Mary KV, on March 21st, 2025, the court issued an order denying the motion of Tony Buzbee for admission to Pro Hoc Vice. In this case, ECF number 76. The plaintiff's local counsel, ClassE, filed a letter dated March 24th in response to the order. She said, Judge, I didn't know. Okay, I didn't know, Judge. Maybe I should have done a better job. And I should have asked Tony, hey, Tony, are you doing your job? Are you actually admitted to practice here? Are you admitted to handle these cases? No, she said, don't worry about it. We'll just take care of it. Shame, 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 shame. As the court pointed, and I want to read this quote from her too. Ms. ClassE represents that she reviewed all the documents in this case and filed them under her ECF because she approved them. So she said, it's on me, Judge. I did it, but I didn't know Tony Buzbee was filing these without being admitted. As the court pointed out in earlier order, however, Ms. ClassE filed on ECF Mr. Buzbee's Pro Hoc application, which included her own affidavit in which she attests, I am advised by Mr. Buzbee that he has never been censored, suspended, disbarred, or denied admission. That's in italicized, or readmission by any court. Ms. ClassE's simultaneously filed as a part of the same application the order of grievance committee of this court denying Mr. Buzbee's application for admission in the Southern District of New York. What? So this is the problem here. So basically, Attorney ClassE in an affidavit said, I'm advised by Mr. Buzbee that he has never been censored, suspended, disbarred, or denied admission. Then the judge is saying at the same time she filed, which Tony Buzbee was required to do, the order the order of grievance committee denying Mr. Buzbee. So it's like, what do you mean? You don't know that he hasn't been denied. You just filed, and this is embarrassing. You just filed the order of the grievance committee showing that Tony Buzbee was denied. So how could you not know he was denied? Anyway, as such, Ms. Cruise, who represents in her letter that she reviewed and approved all documents before filing them on the ECF, filed a document that directly contradicted her own affidavit. Oh man. Accordingly, it is hereby ordered that Ms. Cruise shall show cause why she should not be sanctioned for making false or misleading representations to the court. Again, this legal system moves slower than the music industry. Why does she need to show that, Judge? She messed up. Sanctioned. Like, why are you going to ask her why she shouldn't be sanctioned when she went and filed the affidavit and then filed the order by the grievance committee? It doesn't make it. Why are we giving all this leeway to these attorneys? It doesn't make sense. They should be held to the highest standard of the law, but apparently they're not. The parties shall appear for a hearing on this order to show cause on April 14th, 2025 at 11 a.m. All parties and their counsel are on notice that failure to comply with court orders, all applicable rules, and professional ethical obligations may, there's the word, result in sanctions. Signed by the Honorable Attorney, the Honorable Judge, Mary K.V. Let me know what y'all think about this in the comments and in the chat. Not only is Tony Buzbee taking shots, but he's taking all these people down with him. And I'm just saying, this man's reputation is in the utmost garbage. And all of y'all out there defending Tony Buzbee, let me know, is this someone that right now, today, you would hire to defend you? I want to know what y'all think. Let me know in the comments and in the chat.